BraveFathers.com.
Welcome to the Brave Fathers Show. And now, the prophecy.
Hello. How do you win as a father in UK family courts? How do you deal with CAFCASS? How do you deal with the bias, with the lies, the false accusations, the divorce, the child arrangement orders, and all the other stuff that comes with going through family courts in the UK as a father? My name is John Paul. I come to you from BraveFathers.com, and today I'm going to give you the video I wish I had when I first started going through court. So years ago, as the story goes, there was we could call it a very volatile breakup, and it didn't end nicely, and I was stopped from seeing my kids for a while. I ended up losing everything I had at the time. It was a very difficult period because even family members turned away from me when they heard many of the false accusations. Let me move this way a bit. As this moved. Yes. So when they had many of the false accusations that were brought against me. Now I'm not certain why the camera is moving this way. Let me adjust this. Right. So let's see. I think we're still live. I think you can still hear me. Right. Whoa. Right. I think that's better. I think you can see me more clearly now. So I apologize for that. So this is the video I wish I had when I first started going through family court. So I was stopped from seeing my kids after a very volatile breakup. And it was very painful because even family members turned away from me when they heard the false accusations. It was a thing where it was my word versus the word of the other party, my opposition. And I ended up losing a lot of the things I had built over the years. And it was really, really a rough time. And it got to a point where even the social workers involved, contact centers and so forth, were recommending that I would stop seeing my kids altogether. So as you can imagine, that really sent me on a spiral. But I kept going, I kept fighting, and I fought all the way to the appeal court. So the higher court, I had to appeal the decision that was made in my case. And even then, it was hard because when I turned to people to help me, everybody also became a bit more distant, including some of the people who supposedly support fathers through family courts, which is one of the reasons why I started BraveFathers.com. But I was told things like, listen, less than 2% of appeal cases win. Less than 2% of appeal cases win. It doesn't make sense to go through with it. Just wait a year or two, whatever, and go back to court, and so on and so forth. But I did not agree with that, and I'll tell you why in a moment, because this is important to you as well. So I ended up going through with the appeal. I won the appeal, and ended up with a shared live with order at the end of it. There were still some proceedings afterwards, and I managed to get a positive outcome in all of them. And as of now, I'm happy with the arrangements. And of course, in the future, if I think I have grounds to change things, I will do that. But I'm happy with the arrangement, and a shared live with order is perfect because it helps you combat some of the bias that you'll encounter when you go to schools, when you go to the doctor, the GP, the hospitals, and other places that you deal with. Now, I don't receive child benefits on that in this arrangement. The other side does. So sometimes people say, "Oh, the child benefits determines who's the main parent." That is not necessarily the true way of measuring it. But the best part about shared living order is I don't have to ask for permission to go abroad if I want to, as long as it's within my allotted time. My specific arrangement, of course, requires that both parents alert each other of what's happening, but I don't have to ask for permission. Whereas without a shared living order, the other party could take out the kids of the jurisdiction out of the country for up to a month without your permission. And so it's a very important thing to have. And there are other legal situations where a shared living order really helps. But it was a tough battle. And a lot of the things I'm going to share with you today will change your life if you listen carefully. Like I said, this is the video I wish I had. So I'm not going to hold back. Within the time that we've got, I will share as much as I can about how you can win in the UK family courts. So why is it important to know how to win? Family courts are different from any other court you may have been through, right? So you have civil courts, and it is still governed by civil procedure rules. But family court is different because it's highly, highly subjective. So I remember I was speaking to one gentleman and he said, "Oh, I was lucky to get what I want." I wasn't lucky. I had to put in a lot of work because I understood that it's very subjective. So you can literally not leave any single stone unturned. You have to really commit yourself. You really have to dedicate yourself and focus if you want to win as a father in the UK family courts. There's no way around it because the system is unfair. So, the fathers I've worked with, I've even heard judges say things like, and even in my situations, like, "Oh, we don't usually do this," "Oh, I'm surprised we're doing this," "Oh, I didn't expect this," and so on and so forth, because of the tactics that you can use once you're aware of them. So I will share as much as I can today, but obviously we have a limited time. So get in touch, send a message, leave a comment. Of course, if you have any questions right now, feel free to ask questions. I will answer them live if you are so inclined, or just leave comments and I'll answer them afterwards. But the best thing is just to get in touch so we can see how we can help you. So if you don't know how to win, people will take advantage of you in court right away. Look, I've been to my own hearings and I know that the other solicitor is trying to take advantage of me, but he does not know me, right? So if the other side has a new solicitor or a new barrister and they don't know me, they will try certain things that just waste time and put you at a disadvantage. So understanding how it works, you can say at some point, "Listen, let's not talk about this and that and the other. Let's talk about X, Y, and Z," because those are the things that make a difference. But as an example of how you'll be stalled is the other side will just waste your time, try to fill you out, and then see what your weak points are and then use that against you in court. If you don't know how to win, you will get orders against you that you didn't expect. And one example I can give right away is accepting a non-molestation order. And I've made a video about that. But a lot of fathers accept a non-molestation order with no admissions, being told by their solicitor, "Oh, it's no admissions, it doesn't mean anything," only to find out that they have been essentially cut off from their children's lives. Because again, it's highly subjective. But in general, the judiciary will err on the side of caution. So when you have a non-molestation order against yourself, they will say, "Look, if I allow unsupervised contact and something goes wrong, I will be in trouble," right? The CAFCASS officer will say, "I will be in trouble." Social workers, whoever is involved, will say, "I'll be in trouble. Let's just use it as a reason. I see it as an excuse, but let's use it as a reason to limit contact, and you get some vague promise. Lawyers, again, I've had lawyers look into my eyes and lie, not knowing that I've done the research, that I knew what I was doing with certain aspects of my case. And I still needed help at the beginning because I didn't know the procedure, and we'll talk about that in a moment. So lawyers will take advantage of you. And in general, if you don't know how to win, the odds are already against you. Now they are even more against you, like it's even harder. But if you do know how to win, there's no guarantee, but at least you have the assurance that you are doing the right things and you are doing your absolute best, because that's what you have to do in order to win in family courts. So I'm going to divide this video into 5 sections. This is not legal advice. Seek qualified legal advice. I'm not a lawyer. I'm just a father who represented himself and was able to win an appeal, right? And I had to appeal in order to win the arrangement I had and to build it as a stepping stone. So seek legal advice. Again, get in touch with me as well for extra help. But there are 5 sections that I'm going to share with you based on what I've learned and what I've seen also helping other fathers and reading through the case law and just being in the court environment in general. So the first thing that you really have to know is you should only work with people you trust. And you may be surprised that this is the first point I'm raising. But as I mentioned earlier, even lawyers will lie to you. They just will. They will deny it. People will say, oh, lawyers don't lie, whatever. But you have to understand, most people who interact with your case will have very limited time to deal with it, right? So whereas, let's say, when people use my service, we dedicate a lot of time. Most situations, you get very limited time. And if you're already going through it, you know this. So you have a barrister, for example, and they'll say, oh, he's a good barrister and so forth. Often you just are given a barrister by the solicitors that they are like, yeah, this is the guy, this is the woman, who's going to represent you. And you speak to them literally an hour, sometimes 30 minutes before the case. Every now and then you may have 2 hours of a pre-hearing consultation of sorts, but you can't condense your life and all the things that you want into that short period of time. Now, to be fair, the barrister, if he or she is good, will be able to ask you the right questions and figure out what's most pertinent, what's most important at the stage, and so on and so forth. But the problem with waiting for those 2 hours for that interview is, number one, you're leaving it to chance, whether that barrister is really invested, whether they are really good. But you don't have enough time to really think of what you're going to put in. Like, you don't know what matters, what doesn't. So you could speak for 2 hours, right? So, for example, and you may be watching now and you know who I'm referring to. So I had a conversation with a father. He said a lot of things. And I said, listen, you have to cut down at least 90% of what you are saying. First of all, if you say those things in court, they'll destroy your case. Number two, they are not relevant to the court. But I've seen solicitors and barristers not really raise important points or raise points that are not very relevant, or essentially not really fighting hard, right? Remember, they are officers of the court. Their duty is to the court, not necessarily to you. Not necessarily to you. They have to represent you, of course, in your best interests, but they are not like the ones you see in the movies, right? Like if you watch the movie like The Lincoln Lawyer or any of the legal thriller movies, right? That's not how it is in family courts at all. And even if you've been through civil court, it's not the same kind of pressure that you can put on the court, where you could sometimes or often do it in civil courts, in general civil courts, but the mother has leverage to put some pressure. So that's where things like non-mol and so on go against you. So the reason I'm saying is work with someone you trust, because if the solicitor says to you, "Oh, it's just no admissions, just accept the non-mole," and you have that queasy feeling in your stomach already, and then you do it, they are gonna get paid regardless. But now you've made your life more difficult. You've made it harder for yourself to see kids, and solicitors do tell people to do that. Now, again, I'm not legally qualified, so I'm just speaking of my experience. But I've seen situations where things could have worked out better if the father just fought. And it's so sad to see them cry or see them broken when they realize they won't be able to see their kids for at least a year because of the non-mole. So work only with people you really trust. I recommend you speak to as many lawyers as you can. What I did when I started, I'd literally go to a chancery lane in a town, like, because I was traveling a bit um, within the UK. I'd literally go to where the solicitors are, right? This is usually near the court, like streets with solicitors, and literally go from chambers to chambers, from office to office, getting free consultations. Like, I had no shame, no, like, I didn't care. I just wanted to see the kids. So I said, I'm doing whatever it takes. And through that, I realized that every solicitor will tell you something else. They'll tell you something different. And then little by little, you start building a picture of how things really work. So I don't know how many solicitors I spoke to, but I spoke to a lot. And sometimes they would give you, an appointment for later and so on and so forth. And at that time, let's just say things were not going well in many areas of my life. I don't think I looked my best. I met one of the solicitors years later, and he says, "You look like you were not well." And I think what he meant is I didn't look completely sane, which probably you can relate, because when you can't see your kid, it drives you crazy. And I said, "Yeah, I wasn't really. I was really in a bad state." And especially if you are dealing with a mother that you suspect is narcissistic or has narcissistic traits, or a mother who has some kind of personality disorder and is very malicious, it will drive you crazy. Feel free to ask questions at this point. But the point of the first thing is really, really make sure you trust the person you work with. That's why when you go to so many solicitors, for example, like I did, you realize, you know what, this one is different. This one is giving me better answers than the other. This one seems like he cares, or she seems to really be committed to getting a result. But the second section, the second part is this. There are three levels essentially to your case, like how you're gonna win your case. So the first level is the obvious one, the legal side, right? So that's where the solicitor and the barristers come in. As I mentioned in the beginning, it's a very subjective process. So your barrister and your solicitor have a limited ability to help you in certain instances, which is not their fault. But the problem is many don't tell you this. So when you watch a movie, you think, oh, you could bring some reasonable arguments that make sense. But in reality, they don't, right? That's not how it works. I remember as I was going through it, I was like, wait a minute, it seems like everybody almost knows what's going to happen, but they're not telling me, right? So this is why I said this is the video I wish I had. Because by going to so many people, when I started piecing the picture together, I realized that, wait a minute, okay, so there's going to be some false accusations coming. There's going to be a long time before I see my kid. When I see my kid, I'm not going to see the kid unsupervised, believe it or not. Like the very child you raised, you change nappies and so on and so forth. Now you can't even be alone with that child. So usually a contact center in the beginning. And you're not going to see your child every day. You're going to see your child like once a week or once every 2 weeks. In some cases, I've seen once a month or once every 3 weeks. And so on and so forth. So that would really hurt. Like it really was, I thought it was breaking me. It was really getting to me. So the legal experts, if they are fighting for you, they'll try to maximize the amount of time you get in the beginning. because the amount of time you get in the beginning determines the direction of your court case. So if you are lucky, and rarely, but sometimes it happens, where the mother says she does not oppose unsupervised contact, right? Because a lot of it is based on what the mother is opposing. Then that makes the case harder for her later to stop you from seeing your kids. Because once unsupervised contact is granted, crazy, right? Your own child, but once it's granted, then you basically have a stepping stone to ask for more time. Because usually what you're doing is you're trying to work up to the unsupervised contact stage. Now, again, the courts will always err on the side of caution. So the fact that you're getting only supervised contact doesn't really mean you're a bad person. It's just that they want to keep it safe. And because of the false allegations that will be made against you, and it's enough that the mother says you hurt her, that's enough for you to stop seeing your child, right? So the legal side of it is also the procedure. So if you are dealing with false accusations or any kind of accusations, let's say there's some true ones, whatever, everybody's case is different. Make sure you're familiar with practice directions 12J, PD 12J, because that's where accusations of domestic abuse are dealt with. So the sooner you do this, the better, because time is always of the essence. Like I said, you have very limited time. I've seen situations where the solicitor literally shows up 30 minutes before the hearing, and that's the first time you get to speak to that person. I've had those situations, right? Maybe they read your file, and a lot of times they don't read it properly, right? They just like sort of rush through it. So if you know off the top of your head the most important points, you can write those as bullet points, you can raise them so that quickly that solicitor can use that to represent you. Or if you're representing yourself, of course, then you know them, you revise them. But knowing the legal framework will help you navigate it properly and to help you make a better impression on the judge or the magistrates, as the case may be. But again, it's limited what the legal side is, because there's no right for a father or a mother, for that matter, to see their child. UK does not give parents custody, even though people use that in their everyday language. UK courts don't legally give custody. What they do is they have what they call the live with, spend time with order, or shared live with order, usually. So the most common type of order is live with, spend time with order. As you may guess, it's mostly lives with the mother, spends time with the father. It breaks my heart just saying that, because it just hurts to think of how many fathers the child is just spending time with them, and people would argue that that's in the child's best interest. And that's another part of the legal battle, because everything has to be presented in the light of the child's best interest. But when we look at the second level, which I call the persuasive level, you'll realize that what you think the child's best interest means and what the court thinks the child's best interest means are two different things. Let me give you an example. Let's say you have a mansion, right? For the sake of this example, and you have a beautiful house, swimming pool, cars, everything a child might want, all the toys, you can take the child to private school, and so on and so forth. But let's say the mother lives in a one-bedroom apartment, it's dirty, and she gets high, sometimes smoking weed, for example, or she drinks, or she goes out and just leaves the kids with the neighbors, and so on and so forth. You would think that by logic, the child is better off in the mansion, right? Assuming the father is reasonable and is as good a parent as the mother. So you would think that that's in the child's best interest, right? And I've added the part that let's say she gets high occasionally and leaves the children with the neighbors. But in reality, that's not how the court will see it. The court will see that in many cases, you could argue for the mother and say, look, the neighbors have kids of their own, for example, right? This is just an imaginary case. So the children like playing with them, and that gives the mother some time to herself because of the stress of dealing with the kids. Yes, there's only a one-bedroom apartment for now, but the children are well fed and you're working towards the mother is working towards a council flat that is bigger. So you can't, when you come to the court and say, oh, but I've got a mansion for them, they've got a swimming pool, they've got private schools, and so on and so forth, the court will not see that as the better option, because the opposition will argue the kids are used to the mother, they haven't seen the father in 6 months, and they are settled in their new routine. Right? So so I'm talking of the persuasive side. So the best interest of a child is based on very different criteria of what we would think in reality. But the way I see it is they will find excuses to twist it so that it turns out the mother is the right person for the child to be with. That's what the best interest is of the child. That's how it usually goes. So, but understanding that you have to know how to persuade people, you're chipping away at that position, right? And if there are false accusations, which usually that's what happens, you are essentially stepping back, you are defending, and then planting seeds for the future. So when you're persuading, sometimes you know ahead of time, because you know the narrative, you know how this is go, you know ahead of time of what the situation is likely to happen, or one of the possible scenarios. Sometimes you have, let's say, 3 scenarios, and you're prepared for any of them. That's what it takes to win, right? So if I didn't say that in the beginning, it's a very difficult thing to do. So, for example, you have to persuade CAFCASS to see you as a good parent or a good enough parent. And there are specific techniques for that, right? Just telling them your story is not enough. Again, you have to frame everything from the child's perspective, of what they think the child's perspective is, and how it will benefit the child. Your lawyer cannot do that for you, because your lawyer is not going to talk to CAFCASS for you. You're going to talk to CAFCASS separately, and CAFCASS will write a report. Now, one thing I didn't know, I wish I did know, but I didn't know, is that the CAFCASS report is like 90% of what your order is going to be. Whatever CAFCASS recommends, most judges and magistrates will just go with it. So essentially, CAFCASS is almost like a judge for your case. Now, you can disagree with the recommendations, and you can have a trial where you fight for your position. But in general, you want to get as much from CAFCASS as possible, which is not easy. But the biggest tip I have is don't badmouth the mother. Even if she's done a lot of horrible things, you have to be very specific, show how it affects the child. If it really affected you, let's say she kicked you or something, you have to say when it happened, how it happened, and so on and so forth. And remember, there are false accusations or perhaps genuine accusations being brought against you as well. So you have to be very careful how you talk to CAFCASS. But that's the persuasive side or the persuasive level. You have to persuade them. If there are social workers involved, you have to persuade them. How do you do that? It's not just talking, it's showing them. So, for example, if you're looking for unsupervised contact, you must have where the children will sleep, right? The more toys you have, the more books or things that children love that you have, the more likely that the CAFCASS officer will be persuaded to make a decision in your favor, right? How you present yourself to CAFCASS is very important. So the other part of the persuasive level is your written documents. So that's your skeleton arguments in the trial, if you've been ordered to provide one, your witness statements, your position statements, and so forth. A lot of the time, even the judges don't have enough time to read through all your paperwork. So you have to know how to come across quickly, how to write in such a way that they are almost forced to read the rest. You have to know how to surprise them, sort of, uh, by using a different kind of language from the way most fathers approach the case, from a different kind of premise from which from which you are fighting for your kids. And you have to format them well, make sure it's clear, easy to read, very simple. I would recommend don't use ChatGPT for many, many reasons. But even the judiciary recommendation from what I understand is even they let you know that, look, you have to be careful with this, because ChatGPT and other AI systems will make up things that didn't happen, or they'll give you laws, or they'll put things in a way that you think sounds good, but it doesn't appeal to the logic that the court is going to use to decide on your case. So you really have to do this with your lawyer. Of course, you can contact me if you need help with that, or just study on your own how to write court statements. Because when the judges do read them, a lot of the time, they'll make the decision before you've entered the courtroom, because they'll read the CAFCASS report and that makes their mind. And also your statements, which further um, give them reasons to decide in your favor or not. But you have to know what elements to put in there. So we don't have much time, but you have to show that, for example, if there are false allegations, you have to show how you are taking them seriously, how you are trying to address their concerns. You can't just deny false allegations. You actually have to show that you are addressing the concerns. You have to know your opponent's case very, very well. You really have to. I recommend that you anticipate what arguments they'll use against you, what accusations they'll use against you, and you put things in place preemptively that will make it more difficult for them to lie and to just make you look bad, because obviously you love your kids and you want to see them. So the three levels that I divide my planning and strategies into, and this is what I did in my case, were the legal, the persuasive, and then the last one is the emotional side of things. So the emotional side of things is basically your state. So in the beginning, I was broken, right? I showed up looking crazy. I would grunt, like, I would breathe very hard, like, because I would be listening to all these false accusations, all these lies, everybody talking like my kid is not mine, like I don't matter as a father, like I'm just this person that I'm bothering everybody. And I was just treated like I wasn't necessary, because a lot of people don't think the father is necessary. By law, the father is not necessary, well, you could say the same for the mother, but there is no guarantee that a force that says a parent must be in the child's life. It's thought to be usually the best if it's safe to do so, but it's not said to be necessary or absolutely vital to a child's development, which of course we know is not true. But I'm sure you're aware of how things work in the modern day. So the emotional state matters. So the way I was broken, if I had dealt with my emotions before going to court properly, I would have appeared more calm, more responsible, more reasonable. I would have made better decisions. I would have looked more trustworthy. So I think that could have changed my case early on to move a bit faster, to get a bit more things in my favor, which I was not getting. And when there were opportunities, I couldn't see them because I was so in the negative. And I see a lot of fathers get caught up in the negative emotions. And so they don't really grasp on the little offers that later build up when they accumulate and give you favor in family courts. So you have the legal side level, the persuasive level, and the emotional level, and all are important, right? So I wish I understood that the lawyer is not going to persuade CAFCASS. I wish I understood that. And the only advice I had was, oh, just be truthful, which was BS advice, because I'm not saying you shouldn't be truthful, but it's not enough to be truthful. You have to know how to answer the questions, what to present, what not to present, what to show, how to plan for that CAFCASS meeting, and so on and so forth. And then your emotional state, you may think, oh, it's obvious that I should be in the kid's life because I'm the father. You may think that. But if you show up and they just make a judgment like, this guy looks like, he's angry. And you may be angry just because of the lies, but they will see it as that's the kind of person you are. And that will make your case more difficult. And I wish I didn't underestimate that. When I started processing the emotions, and I talk about this in another video, one time, I was so hurt. I went to the town, there's a big fountain, like huge. I went under, right, because it's like a water arc, and I just cried in the night for like 2, 3, 4 hours. I was just crying and crying. I didn't care that anybody saw me. I was hoping that the water would cover me from anybody watching from outside, but I'm sure a few people spotted me, but I was so overwhelmed with the pain. But after crying my heart out, I became much calmer. I started understanding what I was doing better, and things started moving forward. So we've covered the first two sections, which are only work with people you trust, right? Because sometimes even lawyers are not on your side. And a barrister told me this. She was a former solicitor, actually. And she told me that, look, sometimes the barrister is not on your side, even though you are paying them, right? So make sure you only work with people you trust. There are 3 levels to your preparation. So there's the legal side, which is mostly either your own legal study, which I recommend you do even if you have a solicitor and a barrister, but they take care of that. You have the persuasive level, where you have to know how to convince the different people involved to speak for you. Even the kids' school, it's good to have a good relationship with them, and whoever else may be interviewed for the child impact report, or if there's a Section 7, which I think they're phasing out, if they've not phased them out completely. So Section 7 was just a kind of report. Child impact report is another report. It's kind of different in the sense that it's much faster, and they speak to more people than the Section 7 report, and they could talk to your school, if there's a counselor involved with the kids, domestic abuse advisors, and so on and so forth. They get a whole picture from as many sources as possible. They do police checks as they used to, but now they don't have to ask the court's permission, I believe, to do certain checks, and so on and so forth. So basically, they're going to look into your case. But again, as I said before, it's just going to be a couple of hours talking to you, max, an hour or 2, right? Maybe a little more, but that's it. So they are going to make up their mind. So you have to know how to persuade them with that. And then your emotional state will help you to connect with the people that you may not like, right? So you may not like your CAFCASS officer, but you have to work with him or her because they are the ones who are the most important people to help you see your kids, really. And in my case, because I was able to persuade CAFCASS to see me in a different way, that helped, because the other people were like, just cut him out, because they believed the lies about me. But I was able to get CAFCASS to listen to me, like to hear me out. I answered their questions correctly, because at that point I knew what I was doing, and honestly, and that's how my case progressed. So when you are dealing with your case, especially in the beginning, you may also have some concerns about the children's mother, right? So this is the third section, your concerns about the children's mother. And you have to be very careful about this, because if something is not a safeguarding concern, which basically means if a child is not in risk of danger from it, that is obvious and clear and you can demonstrate it with evidence, then it will be ignored, and it may be used against you in the sense that you may be seen as somebody who is trying to make the other side look bad rather than really care and fight for your children. So you have to be really careful. And I think I mentioned this in this video that I spoke to a father just recently. So if you're watching, and there were so many things that in real life, in the regular life, you'd say, yeah, that's bad, it shouldn't happen, and so forth. But the court does not care, because within their definition of safeguarding, it doesn't matter. It doesn't matter. So for example, you might say, like in the earlier example, that the mother leaves the kids with the neighbors and goes and gets drunk. And then let's say the neighbors are called as witnesses, and they come in as reasonable, well put together people who have their own kids, and the court likes them. Okay, they're not a danger to the child. And then, like I said, the mother will just argue that, look, I'm stressed, they help me out. That's it. It's not a safeguarding concern. Again, you may say it's not fair, but that's why you're here. You're watching this video to watch out for those things, because now you've wasted time. if you put that argument forward, that could be used to find another thing that would actually land, that would actually help you see your kids, that would put the opposition at a disadvantage when they're trying to separate you from your kids for no good reason. So you have to know what to put forward to court and what not to put forward to court. And especially when it comes to accusations. If there's no safeguarding concern, the court will not care, and you will make yourself look bad if you state those things. So that's very important for you to understand what safeguarding is. Now, the next one is something that I've kind of mentioned, but I want to mention it on another level, which is you have to really take good care of yourself. And again, I know it sounds crazy. It's like, how will taking care of myself help me in family court? Like, here's the truth, here are the facts, this is what the lawyer says, blah, blah, blah. No. CAFCASS is going to look at you. They will listen to your voice. They'll try to intuit your emotional state. Your emotional state will be interpreted as how you treat the children and to figure out whether maybe you did the things you're being accused of or whether you did it. But more importantly, you are still the father to the kids. So as broken as you may be, and I have been as well, you have to figure out how to get back to being strong. Because when you stop taking care of yourself, what example are you giving to your kids? And even if they can't see you, you're still their father. And habits accumulate. The actions we take accumulate in effect. So one day you will see your kids. What man do you want them to see? Right? And I understand sometimes you want to take a few days just to mop about and feel sorry for yourself. That's fine. Right? But you have to really start exercising. You have to start doing the things you love. You really have to become a man that you've never been for yourself and for the children. And here's another reason why this is important. Your opposition is going to create a horrible picture of you. So the image that will come to mind when they read the statements in court will be of somebody horrible. But if you take care of yourself and you have this positive, good vibe and you like yourself and you feel good about yourself and you present yourself well, that will then reflect better in your court results. That reflect much better. I remember the things that were being said about me, like how I live in this nasty place, everything is all over, and so on and so forth. And I knew that was coming, right? Because I knew what was in the messages that I was receiving and stuff like that. So I made sure everything looked opposite. My place was squeaky clean. It was nicely furnished. It was, well taken care of, really, like with an effort. Like when you walk in, you just like, like people loved it. People loved it. So when CAFCASS came, they were shocked. They were like, this is not what they were expecting. Right? And I had a couple of CAFCASS officers. So that already made them say, the mother might be lying or exaggerating because he seems to be doing okay, taking care of this, and this is a nice home for the kids to be in, right? So, of course, it doesn't mean they are comparing homes, but if it's good enough for the kids and they think the kids will enjoy it, that helps to get them to recommend unsupervised contact because they can see, look, there are toys, there's a place they can sleep, which the first time I didn't have. The second visit I did have. I got, clothes, things to make it safe. So that really helped because I was taking care of myself, my environment, and just living a nicer life. So I wasn't coming across as depressed. I allowed myself to actually be happy in all this pain. I actually allowed myself to be happy. Yes, it hurt, but I didn't just give up on life. I didn't give up on myself. So over time, after I got rid of my lawyer and decided to represent myself, I had a different energy, right? So the court would listen to me. They could actually pay attention to what I was saying, and I was getting a lot of what I wanted. But in the beginning, I wasn't doing that. I wasn't taking care of myself. And again, that was one of the things that I think slowed me down in the beginning. Whereas if I had paid attention to what I need and want, I would have been able to, what's the word? Just progress faster, right? By the way, before I go to the fifth section, like this video if you like it, follow or subscribe so you get more, and get in touch by clicking the link below to go to bravefathers.com so that you can get some extra help with your family court case. You can get my phone number on there, and then you can send a message on WhatsApp. You can send me a message on WhatsApp, and we'll take it from there. We'll see what best we can do for you. And I always give at least an hour, completely free, no charge, nothing. It's not a pitch or anything. We figure out the best strategy. So these are some of the frameworks that I'm using. But of course, there's way more to be done because each case is different. So get in touch by clicking the link below to go to bravefathers.com. And then if you have any questions, leave comments. And if you just enjoy the video, just let me know, right? I always like to see a good comment, and I will do my best to respond in kind. So the fifth tip, I would say, or the fifth section is you always have to think ahead. Now, I remember one barrister told one of my clients that we shouldn't be thinking about certain things because it was not yet time. And I know he's the lawyer, but I also knew he was wrong. Because again, they are used to following the process, but they get paid, and it doesn't matter to them what happens. I'm not saying they don't care at all, because there's many good ones, so don't get me wrong, but they are trained to think in a certain way. I don't think their code of ethics allows them to, say, hey, look out for the false accusations. I think that's a bit tricky for them to say because there's no evidence of that, even though they know in their experience that will happen. But the barrister was like, no, we don't need to think of X, Y, and Z. But I persuaded my client to still carry on and do them. And we got the result we are looking for, that the barrister didn't think we were going to get. And the same thing in my case. There are certain things I wanted. I said to my solicitor, I said, listen, we need X, Y, and Z. And she was like, no, it's going to be trouble for you. It's going to create problems and so on and so forth. There's a risk. I said, well, I'm not seeing the kids, so I need this and that to be put in place so that when the time comes, we can implement it. She refused. She was giving me excuses, even though before the hearing she said she would do it. But when I got rid of her, I implemented those things, and those things changed the case as well. So there are several things that when you do and the court agrees to them, it moves direction in a positive way, right? And certain things move them in the negative way, like the non-more order I mentioned earlier. So you really have to plan. You really have to plan ahead. You really have to plan all the way up to the final hearing. Of course, it's not going to turn out exactly how you want it. So that's where you adapt. You have to always be adapting. But when you think all the way to the final hearing, you have an endpoint towards which you are working. And fathers who do that, they always have a greater chance of winning than fathers who just go step by step and follow the track. Because the path of least resistance is to stop you from seeing your kids, or to give you as little time as possible. That is the harsh reality. That's the harsh reality. So you really, really have to adapt. And then you review what you do, right? So you go to a hearing, you always feel hurt after a hearing, almost always, because you hear something hurtful. Because again, fathers are not valued in this system. They are not seen as a necessity. Some see them as a hindrance to the kid. And many people believe fathers are just abusive. So you hear things, some of the things will not go your way, some will. You may spot another opportunity, and so on and so forth. So you have to be constantly reviewing. So by thinking ahead, you know how to counter certain things. For example, let's say you know there's going to be a false allegation made. Let's say you have some text messages and you can tell, oh, she's going to lie about what happened in this restaurant, right? Just for example. So what you will do is, you say, you know what, I'm going to go and talk to the restaurant owner or the waiters or somebody who works there, the manager, right? So remember, we talked about the persuasive level. So this is part of the persuasive level. And you're going to say, listen, would you be so kind as to get me footage of the time I was here? It's really important for a court case. There's no order for it, but if you could, right? I'm just giving an example. And they say, yes, you can have it. And then you get it. Now, when the false allegation is made, boom, you have footage, right? Or if you have receipts, or if you know there's going to be a timeline difference, so you may try to produce the receipts. Maybe you paid by card. So you say, okay, let me try and get the receipt that I was here at this time or that time. But you want to get that ready before the accusation is even made. You always want to be 3 steps ahead, 4 steps ahead, 5 steps ahead. Because when the things that you can't foresee come at you, things that you didn't anticipate, you would have taken care of the things you did anticipate. So you have more energy and more chances to win. And in court, one sentence can change everything. One word can change everything. Can change everything. So there'll always be hiccups. There'll always be things that go wrong. So that's why you need to constantly adapt. And you have to review using the framework I just gave you. So as a reminder, what we spoke about was, number 1, you only want to work with people you trust. Number 2, there are 3 levels to your preparation. So you have your legal side, so that's your solicitors, your barristers, your own study of the law. The persuasive side, which is CAFCASS, understanding your opponent's case very well, hopefully better than she does, because remember, there may be a cross-examination. So if you can point out some lies and things like that, that will help you. And then your written documents, how you persuade on paper makes a big difference. It really, really makes a difference. I think I'll have to make some videos on how to write statements that persuade and convince the court. But that's very important. And then your emotional state, the emotional level. So how you feel about yourself, because that's how you'll be treated. And again, I see fathers like lose just because they can't control their anger. They're not screaming in court, but they just look angry. Or I've seen fathers look so afraid, the judge just cannot trust them with the kids. And of course, it's the pressure of the court, it's the lies, the false accusations, and so forth, missing your children. But nobody is seeing it that way. The way you act under that pressure is what earns you the right to see your own kids, if I should put it that way. And I know it's annoying, but that's what it is. You have to be able to speak calmly, even when they are lying about you. Relax. Don't talk over the judge. Don't speak. If you have a solicitor, don't start saying, oh, no, it's not true, and so forth. Don't start sighing. Don't start rolling your eyes. And if the other side does that whilst you are calm, that will start shifting the things in your favor. Because remember, the way fathers win is you build momentum, and then when it accumulates, when it really rolls like an avalanche, that's when you start getting better results, right? So number 3, if you have any concerns, always filter it through the lens of, is this a legitimate safeguarding concern? And this is very important, because if you raise a concern and it doesn't sound important to the court, and you do it again and again and again, you will be written off as a parent who's trying to put the other parent down. And listen, when you look at the CAFCASS checklist, right, from their training and their guidance of what they're supposed to do when they speak to parents, they actually have it there. Like, is this parent trying to make the other parent look bad? And they don't apply it equally to mothers and fathers, because almost invariably the mothers make the fathers look bad. And unfortunately, it's acceptable. It doesn't mean she'll automatically win, but she has more room to maneuver than you do. You understand? You have to be the good one in the end. So how you raise accusations or allegations matters. Let the other side make the mistakes. You don't make the mistakes because, again, as a father, you want to have the best advantage you can have. Number 4, take good care of yourself, because that will show in how you come across in court. When CAFCASS comes to see you or when they speak on the phone to you, how you feel about yourself, how you have to live your life. You can't live your life as if you've lost. You cannot win by living like you are not winning. You have to still go out into the world, still have fun, still allow yourself to be happy in all this hurt. And immediately you may think, oh, this is not possible. But over time, it will be. And that good self-care will give you the strength, the power, the focus that you need to fight for your kids so that they can enjoy you as their father, so you can be there for them, help them grow up and become the kind of people that they are proud of and you are proud of, right? You are still their father. Remember, how you deal with adversity, how you deal with adversity is how you teach your kids to deal with adversity. And that's one thing I don't like when I see some fathers saying, I want my kids to be doing this and that, but you are not doing something similar, right? If it was easy, you and I wouldn't have to have this conversation, right? It would just be easy. So taking care of yourself is a very, very important component of winning in family courts. And then 5, the last section is always plan ahead, always think ahead. Even before you file the papers, you have to get consultations, like speak to me, speak to other people, get a picture of how you think things are going, how they are going to go, and plan ahead. Okay, there's going to be a fact-finding hearing. What are the likely accusations before they come, right? Because the court process is slow. So imagine you file the papers today, but the fact-finding hearing is in, let's say it moves quick, 8 weeks. It's not been ordered yet, but it's possible that in 8 weeks you will have a fact-finding hearing. So imagine that you start preparing before even the other side starts preparing. You now have weeks on them, right? You have so much more of an advantage in that regard to prove the false allegations wrong, because you've been working ahead of time, you've thought ahead. And then you feel less pressure and you appear as more relaxed, more responsible, more trustworthy, and that will help your case. Again, it's not like the regular civil courts where you can just use the law to pressure the judge. With respect, of course, because you can't just pressure them unnecessarily, but there may be laws there are laws that they have to follow. The judges are there to use the law, even though they have a lot of discretion in many cases, right? But in family courts, it's really, really much different. So let's say a statement for a case is late in the family court for 2 weeks, right? Your opposition's statement is late. In a civil claim, you might be able to strike it out. Might be. In family court, you're not going to get a strikeout of the mother's parent just because she was late, even if it was really late, or even if she hadn't done it. But you don't want to be the one who who does that. You always want to be prepared. So if over time you are the one who's always prepared, and believe me, the other side will mess up somehow, then you are just putting yourself that advantage. But again, that comes from planning ahead, and then you adapt. You realize, okay, they're giving me a supervised contact, right? In contact center. So even though it's not been ordered, you're already thinking, okay, so it's not even been ordered yet, right? You have not even filed, but you're already thinking, all right, what are the games I'm gonna play, right? Because if you can engage the child, then the contact center will say the child is happy with you, and so forth. How am I gonna do it? How am I gonna engage the child? How do I plan my schedule ahead of time so that I can really show up relaxed, and so on and so forth. So you adapt, and then you constantly review, right? So the thing is this: The case will take time in two ways. One, you will have to invest time. You will have to, if you want to win. Now, you can try your luck and see where things fall. I wouldn't recommend that, but that's up to you. You may say my solicitor is enough. I don't need really to put any extra effort. I'll just do what they say to do for each hearing. And that's your choice. But if you want to have an advantage, you must put in time. And remember, there will also be delays in court. So time is a very important factor in winning. So how you use it makes a big difference. So that's why I always recommend to my clients, my coaching clients, is that we practice ahead of time. We practice the CAFCASS conversation. We practice certain questions you'll be asked. We practice just learning how to stay calm when something triggers you. So you have to figure out what triggers you, because the other lawyer will try to figure out what triggers you, and your ex will show them one way or the other what triggers you. They'll be able to deduce from the statements. So when you put an effort, you put time in, and you know what you're saying, you know what not to say, when you know what to leave in, what to leave out, that's when you start getting that advantage. And then depending on your case, you'll get really good results. So before I end this video, my biggest advice to you is really take your time and put in time to make it work. Don't deny yourself and your children the life that you could have by underestimating how much time it takes. You have to be consistent. You will have to be consistent. Where I come in is I help take off some of the burden that would be on you so that it's just easier, right? That's how I help fathers. I figure out what I can carry. So for example, if there's written statements and things like that, the drafting of things, things that make it easier, help you ahead of time understand what CAFCASS may say to you, how you come across to people, how you come across to CAFCASS, how your story that you are telling sounds, whether it sounds credible, whether it sounds like a lie, or whether it just makes you look bad. And also how to find holes in the opposition's arguments, and more, and more. But all those things take time. So this is what I have time for today. If you have any questions, leave them below. Like the video, subscribe to me, and get in touch by clicking the link below to go to bravefathers.com. So thank you so much for spending this time with me. I'm going to be making more videos, and I'm really looking forward to hearing your success story. So all the best. I'm going to sign us out. And when in doubt, remember, you are the truth.
BraveFathers.com